Ms. Castillo, you do not live in Texas, is that right?
I do not.
Okay, you're not supposed to be here. The AG might have sent you a letter by accident. This is an interstate case. So, Mr. Morales, you live in Texas, correct?
Correct.
Okay. All right. All right. So they're both present, Mr. Tatum. What do we want to do?
Your Honor, the state is requesting that the court take note that both parties did appear before the court.
I'm gonna note that Mr. Morales is present, but she's not required to be here. So,
Yes, Your Honor. Your Honor, this is a contested hearing. The parties agree that the child is currently receiving insurance through the state through the state of Louisiana for state medical. There's been no request for retroactive support, and the parties agree that the father shall be established as the children's father for all three children here in this matter. All other issues are contested, so we will need to take additional testimony as it relates to those issues. So at this time, Your Honor, the state would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record?
Evangelina Castillo.
From the very first exchange, the judge establishes control. One party does not even live in Texas, and that alone shifts the power dynamic. The court makes it clear that presence does not always mean authority. This opening moment quietly reminds everyone that jurisdiction matters, procedures matter, and confusion will not slow the court down. Before money, emotions, or arguments appear, the rules speak first.
And did you hear what I previously read into the record that was agreed to by the parties?
Yes.
Are you still currently in agreement with those terms only?
Yes.
And as it relates to the children here in this matter, the state has used the father's income of $18 an hour at 40 hours a week to calculate support, and will request that the father pays child support in the amount of $732 per month. Are you in agreement to that amount?
Yes.
And as it relates to medical support, again, based off of the father's reported income, the state is requesting that the father pays insurance in the amount of $250 per month. Are you in agreement to those amounts?
Yes.
All right. Do you have any additional information to offer to the court as it relates to the contested issue of child support and medical support?
No.
All right. Nothing further from this party, Your Honor. At this time, Your Honor, the state would like to call the father here in this matter. Mr. Morales, can I get you to state your name for the record?
Luis Morales.
And Mr. Morales, did you hear what I previously read into the record that was agreed to by the parties?
Paternity, insurance, and no retroactive support. Simple questions, simple answers, or at least they should be. The court is not asking for feelings or opinions, only facts. Are you the father? Are the children insured? Is there any back support requested? This section shows how courts try to lock in basic truths before allowing disputes to explode into something bigger.
Yes, I did hear it.
Mr. Morales, only as it relates to the issues that were agreed to, which again is that the children are receiving insurance through an outside source, which is the state of Louisiana, and there's no request for retroactive support, and that you should be established as the father of the three children here in this matter. Are you in agreement with those terms only, sir?
Depends. How much is the total?
All right, Mr. Morales, are you the father of the children here in this matter?
Yes.
And Mr. Morales, are you in agreement to the request that there be no billed retroactive support?
Oh, yes.
And are you in agreement that the children are receiving insurance through the state of Louisiana?
Yes.
So again, sir, you are in agreement with those terms only, is that correct?
Just for the first couple.
Mr. Morales, you need to listen to the question. He's asked you twice the same thing. You agree with those three things, yes or no? And you keep saying no, yes, no.
Oh, those three things. The last one about the reason is I asked how much is that? How much
I'm
is
not skipping
the total
ahead.
amount gonna be?
I don't know why you're skipping ahead.
Oh,
I want to ask you about the contested issues. We're trying to do the easy part.
Okay.
The easy part is that we think you have three agreements. He's just trying to confirm the three easy parts. He's done it twice to ask you the questions, and you haven't really answered it, other than it sounds like you don't agree with it. So I don't quite understand what the disconnect here. We haven't gotten to the difficult issue yet. He's not asking you about child support or medical support. He's asking, are you the dad?
The father hesitates, repeatedly circling back to money instead of answering yes or no. The judge's patience begins to thin, and the courtroom dynamic shifts. This moment highlights a common courtroom problem. When someone jumps ahead mentally, they miss the question right in front of them. The judge pulls the conversation back, reminding everyone that clarity comes before calculation.
Do you agree that there's
Yes.
insurance through
Okay.
another state? Stop interrupting me because you haven't you're not listening. Are you the dad? Are you okay with the other state having medical insurance? And you okay with you not owing back child support? Yes or no?
Yes.
Okay,
I
that's the
agree to it.
easy part. Just a yes would be good. Okay, then we can. He's going to ask you questions about the contested parts. But I got to get this easy part, or maybe you say I don't agree to anything at all. Then let's talk. Then we start all over again. Do you understand what I'm saying?
Yes. Yes, sir.
Okay. All right, Mr. Tatum, go ahead.
Thank you, Your Honor. And sir, you are currently employed, is that correct?
Yes.
And is that at $18 an hour at 40 hours per week?
Yes, sir.
You have no additional children outside of this case, is that correct?
No.
And sir, just confirm you stating that you do not have any additional children outside of this case, is that correct?
I don't.
Okay, thank you, sir.
Yes.
And as it relates to the medical support, based off of your current income, the state is requesting, sir, that you pay insurance in the amount of $250 per month. Are you in agreement to that amount?
250. That's fine.
All right. And as it
Yes,
relates
sir.
to the, thank you, sir. As it relates to the child support, based off of your current income, the state is requesting, sir, that you pay child support in the amount of $732 per month. Are you in agreement to that amount?
Child support is set at $732, medical support at $250. Suddenly, the abstract becomes real. The father does the math out loud, realizing this is not theoretical anymore. The judge explains garnishment like taxes, automatic, and unavoidable. This segment shows how courts translate income into obligation, and how quickly confusion turns into acceptance.
That's fine. Yes, sir.
So just to confirm, sir, you do agree to paying the child support and the medical support as provided to the court today?
Yes, sir. That's fine.
All right. Nothing further from this party, and it appears that we have a fully agreed order.
Okay. Do you understand everything we're talking about, Mr. Morales?
Yes. Basically, it's okay for me to speak.
Well, do you understand everything? That's what I'm trying to find out first.
Somewhat. Somewhat.
Okay.
Because I'm sorry, sir. I didn't know if you were going to say something or not.
Well, I was going to ask you, what is it you don't understand?
The end part is 250 plus 732, and how much would that be? And this is my first time. That's why.
I don't know. I got to get a calculator just like you do. I don't know. 982.
982, and that's every paycheck, or they break it up in two paychecks since I get paid bi-weekly.
Yeah, they'll break it up into your paycheck. So it won't come out all of one paycheck. It'll be like a portion out of each paycheck, roughly about half, but it's a little bit less than half per paycheck if you get paid bi-weekly. And it'll just come out of every paycheck.
Okay, but that's besides the taxes and the federal and everything.
It'll come out
So
like the
basically,
taxes. It'll come out like the taxes. It'll just come out of your check and you won't receive it at all. It'll just go straight to
Okay.
child support.
so I go to child support.
The father admits he has a second job and worries about double garnishment. The judge explains the system calmly but honestly. Mistakes happen, but they can be fixed. This exchange reveals a rare moment of reassurance inside a strict process. The court is firm, but it also acknowledges that navigating enforcement systems can be overwhelming for first-timers.
Okay, so and I got one more question. I got another job since I go pay child support. Since I have to live my life and I have to save some money so I can visit my kids because they live 7 hours away, and I want to make sure I have the extra money to visit them. If I don't have the money, then it's gonna be hard for me to visit them. So I just want to make sure they ain't gonna take no money off for my second job.
They shouldn't need to as long as you have enough paid out of your first job. So
Okay,
if you're paying the full amount out of your first job, sometimes what happens when people have two jobs is send that withholding order to both jobs to take the same amount out of both jobs. And so as long as you're paying through the one job, if you get a letter for the second job or they take it out of your second job, then you need to call the AG's office and complain and say, hey, you're already taking out of one job. I don't need you to take it out of both. And then they can correct that. But so if you have that problem, you can call them back and tell them that. But as long as you're making full payment out of one job, then we should be good. All right. The Attorney General's office is going to put that in writing, email you both a copy, Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you,
Thank
Your
you.
Honor.
Charlemagne Carbs.
In the name of the child or children that we're here in reference to,
Her name is Clarissa McGee.
in the name of the child's father,
Durante McGee.
all right. Just one moment. And has there been any issue relating to family violence between you and the other party to this case?
Not family violence, just what's the word I'm looking for? Disruption.
All right. Are you currently in fear of your safety or your child's safety?
No.
All right. As it relates to your address, does the other party have that information?
He does, but I'm about to move and I don't want him to have that, my next address.
All right. If there is no current family violence and there has been no prior family violence and you're currently not in fear of your safety or your child's safety, is there any specific reason why the father should not have your address going forward?
Because he's going to call CPS once the child support goes up, and I don't want to fight that.
All right. And the state has used the father's previously reported income at $2,761 per month for the calculation of support, and will request that the father pays child support in the amount of $465 per month. Are you in agreement to that amount?
Yes, sir.
And as it relates to the insurance, how does your child currently receive insurance? Is it through the state or through your employer?
It's through the state.
A mother asks to hide her address, not because of violence, but fear of CPS reports. The judge shuts that argument down firmly. CPS is not family violence, and speculation does not override court orders. This moment is powerful because it separates emotional anxiety from legal standards. The court makes it clear. Orders are not optional based on discomfort.